address. Your Honor, at the time of plea, committed in count number 1 that was US $20 million.
The witness here already. We say Kenyans don't keep time. Either they come early or late. Unaitwa nani? Yes. So you'll be having how many witnesses? Pole, wajipange vizuri. The third one is kaeni tafadhali.
We have Mr. Kesa also, very competent. Mr. Gashok, I think, wants his voice to be heard.
Good morning, Your Honor. For information today, for the state to inform the court as to how it intends to deal with the matter before the hearing dates of the 29th and 30th July this year. Your Honor, when we were last before you on the 28th of November 2023, one prosecution witness testified. Counsels for the accused person, after the testimony of that witness, off the record. We look at the charges facing the accused persons. And on the 21st of February this year, I did brief the DPP of the matter. Through a brief dated the same date. The brief raised issues of evidential threshold, finalities of the charges before court. On 12th March this year, the DPP did direct that I do move this court to withdraw the matter. Yes, Your Honor. On the 12th of March this year, after the DPP had given directions that the matter be withdrawn, and before we could move the court to have the charges withdrawn, on the 18th of March, 6 days later, the High Court sitting at Nakuru, Constitutional and Human Rights Division, petition number E016 2023 delivered by the Honorable Justice Mohochi, did declare section 77(1) as unconstitutional. The penal code. Also declared unconstitutional was section 377 3A, B, C, D, E, and F, and G of the penal code. A, B, C, D, E, F, G of the same act. It's reported at Kenya law. Having regards that the sections declared unconstitutional are the same sections facing the accused persons before you, it stands that the charges before you with regards to all the accused persons have been nullified by that judgment. That this court be guided by that authority and stays at the same position and finds that the charges before court have been nullified by that position.
Charge. And for the communication that he issued on the 12th day of March 2024. But Your Honor, it is important that even as you give your directions in this matter, that the submissions that we took, I believe, more than 2 hours to submit. Your Honor, on the 20th day of July 2023, are reiterated. Your Honor, in our submissions, Your Honor, we submitted very clearly that the arrest of the accused persons was political, purely political, Your Honor. And amounted, Your Honor, to abuse of judicial process when they were arraigned here in court. Your Honor, it also signified, and today's submissions by Mr. Gashoka crystallized this issue. This is a very serious issue. The fact, Your Honor, that the decision to charge, Your Honor, a power solely vested on the DPP, is supposed, Your Honor, to be exercised neutrally and without any favor. Such that, Your Honor, the fact that the same DPP who approved those charges is still the same DPP. It was not the time of Nordin Haji. It's the same DPP, Your Honor, who has come on board. Oh, yeah, it is still the same office, Your Honor, I'm being corrected. It is still the same office because there's continuation of office. It's still the same office, Your Honor, that has decided less than 1 year down the line to take a different stance. Courts of law are faced with such matters, Your Honor. It speaks loudly as to why the doctrine of innocence must always reign supreme, even when the checks and balances in our Constitution fail. Great lesson to the prosecution, not to just become the white colonialists of today to persecute their own brothers in matters that they know very well is actually something that we should have left in 1963 and 1964. But my brother, Mr. Gashoka, I'm happy. I'm sure he will communicate the same, even as I speak. But just to finalize, Your Honor, to the very able submissions by the counsels who are here. I wish they were here, the prosecution counsels. They were the entire realm of the DPP was here that day. Today they've only sent Mr. Gashoka to deliver the bad news. But they argued to a point that this court, we thank God and the court that you accorded them bond terms and cash bail options. They struggled to meet them, but they still met them nonetheless. We will pray that the court directs that the money deposited as cash bail be returned to the depositors. If our clients are grateful for our services, we will accept it and be returned to the advocates. Then we can. And we really hope in future such sums, if there are such withdrawals, should even attract interest by the office of the DPP. But to that extent, Your Honor, we are grateful, and I think through that, any other personal items that may still be with the investigating officer, Your Honor, belonging to the accused person, should also be returned to them. And I hope Mr. Gashoka will be minded that we are going through another finance period. There might be demonstrations I've had. Let them not try to again look for other sections to bring people here, because Kenyans will be up in arms in their numbers. So let them not look for other sections, and if they do, Your Honor, kindly grant these people personal bond. Thank you so much, Your Honor. My
clarification that, Your Honor, at the time the 7 were charged, we did raise an issue that the office of the Director of Public Prosecution was vacant. And had just lost the race to occupy that office. The one who succeeded was in Parliament for betting. Immediately he was sworn in as the substantive DPP. He wrote to that public officer to review the decision to charge the 7 pursuant to Article 157(11). That decision is what good brother State Ashoka has presented, that the DPP made a decision to withdraw these charges. before the High Court decision. Therefore, on behalf of the 7 accused persons, we thank the Director of Public Prosecution for making that bold decision supported by the Constitution. Number 2, Your Honor, the first accused person is a member of Parliament. He has undertaken to review the penal code. And move to either amend or repeal all colonial provisions to avoid a situation like this one, where Kenyans are arrested, charged, then we do applications for review, so that is the gift the first accused will give the country. And unless the penal code is cleaned by Parliament, it will be an abdication of the Parliament's mandate which now goes to the petition in Nakuru High Court. My brother Okach has called them the heroes of the freedom of speech and the right to demonstrate. It is a momentous time in the history of Kenya. That now it is loud and clear that Article 37 is absolute. Every type of battle has casualties. Every form of happiness, a few must shed their blood. The 7 shed their blood and their liberty for 55 million Kenyans. And the fountain of liberty and freedom shall now be the guiding compass for the new Republic of Kenya fundamental human rights are protected. That's all.
But I would also like to state that there's a good day, there's another win for the Constitution, another win for the people of Kenya, that the rights and the status that is protected in the Constitution is upheld by the courts. And indeed, we thank the courts for the same. I wouldn't like to belabor submissions already made by my seniors. I believe that the submissions that my seniors have already made are sufficient for these courts.
Good work being done by the DPP's office. Not only timely review of decision to charge, which is in line with the DPP's agenda, but also appreciating that we do communicate. The office of the DPP communicates its decisions, listens, and Your Honor, you'll note that on the 28th November last year, when off the record counsels asked the DPP to look at the charges, 28th November. Yes, Your Honor, get it, Your Honor. Then briefly, criminal cases evolved, and that is what led to the DPP making a decision to charge after the testimony of PW1. As at the time of charging the accused persons, Section 77(1) of the Penal Code is still the law. The same has been nullified.
I have considered the submissions and also perused the authority of Katiba Institute and 8 others versus the DPP and 2 others. High Court Constitutional and Human Rights Petition number 016 of 2023, which declared the provisions under which the charges in this matter have been instituted as unconstitutional, and based on that decision, the application made by the prosecution is merited. The case is therefore terminated under Section 87A of the Criminal Procedure Code. Cash bail deposited to be released to the respective depositors thereof. Orders accordingly.